with NGOs and other public bodies. She also finds the time to not only lectures regularly on these issues, but she also gives conferences, like what she's doing today, and she also writes about these specific legal topics. And so the title of today's conference is Gender Diversity in the Judiciary. And so there will be a question time for those who feel like, and I'm sure you will find a lot of questions for her. And so Karen, the floor is yours.
Thank you very much. Should I just go into this one? This is stand up. Okay. I'll stay seated. I'm generally happier standing because I'm short, not for no other reason except that generally. But I'll try and project my voice, notwithstanding my limited height. If you can't hear me, then please just do indicate. My focus is going to be on the United Kingdom, although some of the observations I'll make will be equally applicable elsewhere and perhaps have more general import. Firstly, to start, as a woman barrister, I'm a minority in my profession in the United Kingdom, and I would be part of an even smaller minority if I joined the senior judiciary in the United Kingdom, assuming that that opportunity were made available to me, which is extraordinarily unlikely. The senior judiciary in the United Kingdom rates very poorly for diversity, including gender diversity, as compared to the rest of the world. The judiciaries of the countries in the Council of Europe average 52% men and 48% women. In 2010, England and Wales was fourth from the bottom, followed only by Azerbaijan, Scotland and Armenia. Professor Alan Patterson of Strathclyde University has undertaken a comparison as between the 34 countries of the OECD. At 8%, the United Kingdom was rock bottom for gender diversity, 8% women, rock bottom for gender diversity, albeit closely followed by Turkey. Even in the other common law countries, they do currently much better than the United Kingdom. 4 out of 12 judges in the Supreme Court of the United States are women, 4 out of 9 in the Supreme Court of Canada, 3 out of 7 in the High Court of Australia, and 2 out of 6 in the Supreme Court of New Zealand. In the United Kingdom, we have 1 woman judge in the Supreme Court. She was the first woman judge in the Supreme Court, and she's the only woman ever to have sat as part of the 12-member United Kingdom Supreme Court. 14 men have been appointed to the Supreme Court since she was appointed. Only 8 of the 38 judges in the Court of Appeal, our first-tier appellate court for serious cases, are women, and only 21 of the 108 High Court judges, that is our most senior first instance court, are women. This lack of diversity extends to other characteristics, in particular ethnicity, sometimes of course intersecting with gender. As the statistics that we do collect, or the judiciary does collect in relation to ethnicity, are incomplete and flawed, which says something about the value of racial diversity for the judiciary by itself. But even allowing for that, we know the position is exceptionally poor. No current or past member of the Supreme Court or the Court of Appeal has ever been black or from an ethnic minority group. And as at the 1st of April 2014, there was only 1 member of the High Court bench, comprising 106 judges, who identified as black or from an ethnic minority group. So virtually no racial diversity. As to gender diversity, the focus of this presentation, we can see something of the explanation for the absence of gender diversity in the professional backgrounds of judges. The vast majority of judges in the United Kingdom at senior level were barristers before their elevation to the bench. All current Supreme Court members of the, all present Supreme Court judges were prior to appointment as judges, barristers. There is only one exception, and that is the only woman in the Supreme Court who happened to come from academia, exceptionally. All members of the Court of Appeal were barristers, and all bar one members of the High Court were barristers. All also came from super privileged backgrounds. A recent report demonstrates that 71% of the senior judiciary attended a private, that is a non-state school, 71% as against 7% of the population overall, and 75% went to Oxford or Cambridge, our elite universities, as compared to 0.8% of the population overall. As I'll come to, there's been little support in the United Kingdom for introducing targeted directive measures to achieve greater gender diversity in the judiciary, or to address some of the structural issues, again that I'll come to, that cause the absence of gender diversity. The public insistence, however, from the judiciary and for the selecting bodies is that they want a gender diverse judiciary and they will do everything they can to achieve it. In my view, they don't, and they will not, and they certainly are not doing everything they could to achieve a gender diverse judiciary. The fundamental difficulty, some say, in securing a gender diverse judiciary is that the judge, the senior judge in particular, is constructed as male. The default judge, as Erica Rapley puts it, is a man. The same is true of barristers, who form the pool from which most senior judges are appointed, as I've just indicated. This is manifested not just in external indicators, such as dress, but also in the structural arrangements for appointment, which at least arguably conflates the concept of merit, the threshold for appointment, we're told, with gender, as I'll come back to, and in the terms and conditions on which senior judicial appointees hold judicial office. But the logical prior question, before I come to all of that, is why it matters. Should we care about the absence of gender diversity? I'm not sure this is making any difference, is it? It is it? Okay. Whether it matters. Why do we care about whether or not we have a gender diverse judiciary? Does it add anything to the judiciary itself? Well, the three reasons that are usually identified as pointing to the value of gender diversity is firstly, democratic legitimacy. Secondly, fairness and equal opportunities. And thirdly, the need to secure the best justice, that is, justice that's sensitive to the experiences of all parts of the community, that justice is dispensed for all. A further less well explored question, and I'll touch upon this briefly, is what difference, if any, the presence of a woman judge on the court makes to the advocates who appear in court, specifically to what and how arguments are put, and the basis, therefore, upon which cases are decided, in particular in the United Kingdom's adversarial system. So whether it matters or not, firstly, as I've said, the first reason given ordinarily is democratic legitimacy. The more diverse a judiciary is, the more likely it is that their judgments will have and will seem to have greater democratic legitimacy. That's generally an uncontroversial proposition now. Judgments handed down from a judiciary composed both of men and women are more likely to attract broader democratic support than those handed down by an elite and exclusive class of men. Also, Again, generally uncontroversial. The absence of women in the senior courts points to a lack of equal opportunities and unfairness for women. The law has afforded women formal equality in the sphere of employment and occupation in the United Kingdom for decades now, and indeed in the EU, and therefore across all member states for many decades. Women are entitled to expect that they will have the same chance as their male colleagues to become a senior judge, and there's broad support for that view. The figures taken at face value for gender diversity seem to indicate that they are not being given a fair and equal opportunity for appointment, at least at senior level in the judiciary. The failure to recruit from across all sections of society, women in particular, for judicial posts at the senior end of the judiciary, has been the subject of comment in the United Kingdom, as indeed elsewhere. Lord Neuberger, our President of the Supreme Court, has put it like this: the idea that women are less good judges than men is fanciful, but if that's right, why are 80% or 90% of judges male? It suggests purely on a statistical basis that we do not have the best people, because there must be some women out there who are better than the less good men who are judges. Indeed, it might be said that there are some women out there who are better than the best male judges, but no doubt our most senior judge, our most senior male judge, couldn't contemplate that as a possibility. But in any event, it's recognised that the absence of women at senior level points to the absence of equal opportunities, and it's uncontroversially regarded as significant and important that we secure equal opportunities for male barristers seeking elevation to the court. The third, more controversial question, usually raised in this context, but much more controversial, is whether, in fact, the presence of women judges makes a difference in individual cases and to the body of law more generally. The evidence on that issue is somewhat equivocal, not least because it's difficult to objectively assess in retrospect. Some feminists say that it simply must make a difference. The presence of women on the bench must make a difference. Others say that it probably does when one takes account of the craft of judging, what tasks are undertaken by judges, and the judgments that are brought to bear on the work they're required to undertake. Lady Hale, the only woman, as I've indicated, in the Supreme Court in the United Kingdom, has observed that the business of judges, especially in hard cases, often involves a choice between different conclusions, any of which it may be possible to reach by respectable legal reasoning. The choice made is likely to be motivated at a far deeper level by the judge's own approach to the law, to the problem under discussion, and to the ideas of what makes a just result. As she went on, an important project of feminist jurisprudence has been to explode the myth of the disinterested, disengaged, and distant judge. It's difficult to see, in my view, how the experience of being a woman in a gendered world could not make a difference to outlook. And in some cases, therefore, perhaps only a few, but in some cases, to the view that a woman judge holds as to what the result should be in any particular case. That's not to mean, of course, that a woman judge will make a decision in accordance with what she thinks the result should be, but in marginal cases where a decision could respectively go either way, then in that context, the position of the judge, the gender of the judge, arguably, indeed in my view, inevitably, will make a difference to the outcome. That's no different from the position of a male judge, where his gender, his life experiences, again, are likely to affect, in marginal cases, and in perhaps only a few cases, but nevertheless importantly, what he perceives to be a just outcome. Other feminists, however, say that to suggest that women qua women make a difference to justice is essentialist and to be deprecated. What makes a difference, they say, to the outcome in any particular case and the body of law that's developed is whether a judge is a feminist, not whether they're a woman. So Sally Kenny, for example, has commented that feminists who argue for a premise of sex difference whipsawed between arguing that women would bring a distinctive perspective to the bench and criticising those women who did not. Of course, if it's feminists and not women as such that make a difference, then men who are feminists will just as well do. Rosemary Hunter, in this context, what makes a feminist judge, has identified several features that she says indicate a feminist approach to judgment writing. She identifies these as follows. Firstly, asking the woman questions. That is, noticing the gender implications of apparently neutral rules and practices, as well as their implications for other traditionally excluded groups. Including women, that is both in terms of writing women's experiences into legal discourse, as individual litigants collectively, and collectively drawing on relevant research evidence, and in the construction of legal rules. Thirdly, challenging gender bias and legal doctrine and judicial reasoning. Fourthly, contextualisation and particularity, so reasoning from context and the reality of women's lived experiences, making individualised rather than categorical or abstract decisions, and paying particular and careful attention to the individuals before the court, not judging women's choices from those as compared to those that a judge might themselves have made. Fifthly, seeking to remedy injustice and to improve the conditions of women's lives. Sixthly, promoting substantive equality. And seventhly, drawing on feminist legal scholarship. Whether these questions could only be asked by women judges is contestable. Certainly, in my experience, they're not asked by the male judges in the United Kingdom. That may just be my experience. Certainly, again, looking at my experience, it does seem to me that one particular, less well-explored significance of having a woman judge on the court is the way advocates respond, the way advocates formulate and present arguments. As I say, that's been very little explored in the academic literature on gender diversity and the significance of women on courts. But as any advocate will tell you, we tailor our arguments to suit the court that we will be arguing before. The most anxious moments for an advocate in an adversarial system is awaiting the list that will tell you what the constitution of the court will be. We want to know what judges we're going to be faced with. When we find that out, we finesse our arguments, we shift them, we tweak our draft oral submissions, we look up what the judge has said judicially and extrajudicially about the issue that's likely to be argued before the court, and we formulate and present our arguments accordingly. And just to give you one example, presenting an argument in relation to domestic violence, where one is having to argue that domestic violence reflects the broader patterns of inequality experienced by men and women in society, sotto voce, explaining why there's no women judges on this court, my lord, and that domestic violence is widespread, sotto voce, my lords, you may well be perpetrators or have some amongst you, and I am much more likely to be a victim, is a much more challenging argument to make before an all-male court, because it fundamentally challenges the legitimacy of the court. If one has a woman on that court, it's a much easier argument to make. I've never been presented with an all all-male court having to argue those points. Fortunately, on the last occasion on which I had to argue it, there was a woman on the court, the most senior woman, Lady Hale. And so I was able to focus my arguments at her and hope that the male judges would be too embarrassed to challenge her about the observations that I'd made when they go back into their retiring rooms. But it does seem to me that that's an area that could be better explored, I think, by academics, because I do think it's significant. And in an adversarial system, of course, it's critical, because judges are only permitted to make decisions on the basis of the arguments that are put before them by counsel. As to how we've got to where we are, why do we have courts that are predominantly at senior level comprised of male judges? Well, first of all, as I indicated earlier on, the explanation lies in where they come from. They are almost all ex-barristers, almost all ex-Queen's Counsel, that is, barristers at the most senior level in the profession. What we know is that barristers are predominantly male. This is notwithstanding that for many years now, women outnumber men as law graduates, and they are also more likely to secure first and upper second degrees as law graduates. That is, they do better than their male peers as law graduates, but they are less well represented at the bar, and indeed they fall out in greater numbers at each of the milestones. So the higher up you go amongst the barristers' profession, the fewer women you'll see. The very high attrition rates for women are explained by the culture of the bar. Very long working hours are generally required. There is a culture of visibility. One has to be seen and one has to be available. That is not a career that's entirely comfortable for many women, particularly those who have children. We are still also required to wear, and I can almost not believe I'm having to say this, but we also have to wear formal court dress. So as a 21st century woman, I am required, as a condition of appearing in court, to dress as a 17th century man. I must wear a wig, a waistcoat and a gown. And indeed, when I started in practice, I was prohibited from wearing a skirt or a dress, even under a gown. So the assumption would be, as a barrister, that I would be a man, and that had to be evidenced not just in the formal court dress, but in the ordinary clothes that I was required to wear underneath. And if I did not wear those clothes, I would not be heard. So one of my earliest experiences as a barrister, not as a very junior barrister actually, but one of my earlier experiences in court was standing up, and before I opened my mouth, the judge said, "I cannot hear you, and nor can I see you." And I was utterly bemused, of course, and I paused, and he said, "I cannot see you, and nor can I hear you." And my opponent nudged me and pointed down, and I had left my wig on the seat next to me. So I put my wig on and stood up, and he said, "Now I can hear you, and I can see you." On another occasion, where I allowed my gender to be revealed, I was treated with equal contempt. I was asked by a judge, again before I'd said a word, "Are you a miss or a Mrs.?" I said, "I'm a mus." And he said, "Are you a miss or a Mrs.?" I said, "I'm a mus." And he said, "Are you a miss or a Mrs.?" And I said, "I'm a mus." And he said, "Well, I shall call you Miss." And so I wasn't even able to be heard until I had identified my marital status or been given a default marital status by the judge. In addition to those features of the bar, There is also a tradition of advocacy which is highly adversarial. Good advocacy is characterised by a sparring and robust style, reminiscent of the oratory adopted in private schools and in debating societies in the Oxford universities. So it's a culture which is very male, and it's a profession in which women are a minority, and a smaller minority the further up one goes in the career ladder. So Queen's Counsel, for example, very low numbers of women barristers amongst Queen's Counsel, about 12% or thereabouts. It's been increasing, but still very low. So it's a very male profession, and that is the pool from which senior judicial appointments are made. So it's barely surprising, I suppose, that our senior judiciary is dominated by men. As to the judiciary itself, the terms and conditions are themselves very male. They assume that judges will be male. So firstly, all salaried judges, that is proper substantive judges, we have a pay system as well, but I'll leave that for the moment. All substantive judges work full-time at senior level. There is notionally the availability of part-time work for the senior judiciary, but nobody holds a part-time appointment, which speaks for itself, and there's no right to hold a judicial post part-time. That lies in the discretion of the Lord Chancellor. Secondly, as a part-timer, even if one worked part-time, one would not be able to maintain any connections with private practice. That means a woman, for example, who would want to work part-time in a secure judicial appointment whilst her children were growing up would not be able to maintain any connections with her practice, something she might want to return to after her children have grown up. There's no statutory bar in addition to returning to practice after holding judicial office, but that is prohibited as a matter of fact by the Lord Chancellor. So one can't move from practice to the judiciary to accommodate changes in life experience or where one is in life. Fourthly, again, I can barely imagine that I'm having to say this in the 21st century, leaving aside wigs and gowns, which is still part of the judicial regalia, but we also have what's described as a circuit system. This requires London judges, almost all senior judges are based in London, London judges to traverse the country, staying in grand mansions with butlers and staff, and sitting in regional courts. The view being that regional judges could not be trusted to administer justice without the supervision of senior London, open brackets, male, close brackets, judges, and the obligation to go on circuit and stay in these grand houses with staff is a requirement that extends to many weeks at a time. So one's required to leave their home, their children, their partners and their friends, to spend weeks away in grand houses. Again, not something most women would want to accommodate. The culture of the judiciary, again, is very male, no doubt reinforced by the working practices and the backgrounds of judges, as I've just described them. It's very common, indeed usual, for male senior judges, including at Supreme Court level, to be members of male-only clubs, that is, to be members of clubs that exclude women. That is considered entirely usual and entirely acceptable. So a very male culture. As to the future, where we're going to go, there's very little optimism amongst women and feminists in particular. There's very great resistance in the United Kingdom to having any sort of targeted measures directed at increasing the number of women judges at senior level. Judicial appointments are said and required to be, as a matter of statute, to be made on merit. Merit is not defined by the statutory provisions addressing selection, and is barely defined by those responsible for selecting senior judiciary, members of the senior judiciary. The skills identified as necessary to meet the threshold of merit for senior judicial appointment are frankly trite. Things like intellectual capacity, efficiency, I mean, these are barely nuanced, barely capable of any deep and meaningful understanding, and inevitably going to be required of any judge. Nobody's going to suggest that an absence of intellectual capacity should qualify one for the holding of senior judicial office. So no real defining of the concept of merit. Objectivity is said to be required, but that very much, of course, lends itself to being seen through the lens of a male judge. What is objective can be entirely gendered. So, as has been observed, merit is very much in the eye of the beholder, and those who select judges and make recommendations for appointment and provide references for judges are dominated by men, and dominated in particular by male judges. The Judicial Appointments Commission that's responsible for appointing, for selecting for appointment most senior members of the judiciary, has some positive action measures available to it. In particular, there are what's described in the United Kingdom as tie-break measures. So if there is a man and a woman that are rated equivalently, that is regarded as of equal merit, the Judicial Appointments Commission is permitted to prefer the woman. According to the chair of the Judicial Appointments Commission, there has never been a selection exercise amongst the 500 with which he's familiar where a woman has been rated as equivalent to a man, and so there has been no need to apply the tie-break provisions. So whilst they're there, they're never used. Many of us now regard quotas as essential. There is huge resistance to gender quotas in the United Kingdom. Geographical quotas are now fairly common. So the Supreme Court, as a matter of practice, will have a judge from Scotland and a judge from Northern Ireland amongst its number. But gender quotas are thoroughly resisted, deprecated entirely. In my view, we need gender quotas. It's the only way we're going to move away from the vision of a judge as quintessentially male, to introduce some critical mass that would change the face of the judiciary. As I've said, there's considerable opposition. EU law is sometimes raised as an obstacle to quotas in the judiciary. That's paradoxical for any of you who know anything about the UK, because of course our dominant political narrative is that the EU is a terrible place. But where we're looking at gender quotas, suddenly EU law is called upon as a reason for not introducing them. In fact, in my view, as somebody who practices in the sphere of EU law, there isn't, in fact, anything in EU law that would prohibit the introduction of quotas where the representation of women at senior level is so low, and indeed quotas for the senior judiciary in the apex courts in other European countries is now very much a reality. Belgium most recently has introduced, for example, gender quotas. So where we currently are in the United Kingdom is that we are pretty rock bottom, as it's been said, for gender diversity in senior courts. That won't change whilst we recruit senior judges from the bar, from amongst senior barristers, and nor is it likely to change whilst the culture remains as it is, working practices remain as they are, and that we don't have critical mass, which will only be, in my view, achieved by the introduction of quotas.
Thank you very much, Karen, for this enlightening conference. I think that if anyone wants to ask a question, I will pass on the mic. Oh, you're very popular. I'll start with Linda, then... yes.
Fantastic presentation.
Thank you.
In the United States, we have more women in the judiciary, both on the state level and the federal level, because in the case where judges are influenced by the leadership of a particular party, women have been active in securing support for politicians, and also political leaders such as the president and senators have used appointments to the judiciary in order to catalyze female support for their parties. What's the difference in Britain? Why isn't there a linkage between female support for the party in power and appointments to the judiciary? Perhaps there's a different system.
It is a different system, and in fact you touch upon an extremely important point for UK lawyers more generally. I talked about democratic legitimacy earlier on, and I talked about democratic legitimacy in a fairly abstract way. That is that in general terms, generally judgments are more likely to attract more support if they're made by a diverse court. But in terms of democratic legitimacy as it's more usually used as a concept, we have very little of it insofar as judges are concerned. We don't have political appointments. Judges are selected by an independent body, a quango effectively, a statutory body, and although the contribution judges make to the selection of judges is very considerable, the contribution politicians make is negligible. So it makes little difference to a political party what the constitution of the judiciary is, because they're very unlikely to be able to take any credit for it. Interestingly, the Labour Party that's presently in opposition in the United Kingdom have undertaken or have commissioned a paper from, amongst others, me, asking what it is, if they get in power, they ought to do. So they are trying to politicise the constitution of the judiciary and the need for diversity in the judiciary that hasn't hitherto been seen. We've said they should introduce quotas. We'll wait and see if they do. But yes, it's an interesting point. Our system is entirely different. There's nothing to benefit a politician in increasing diversity in the judiciary or gender diversity being increased in the judiciary, because they can take no credit for it. So, very interesting. And many of us think, actually, there ought to be more democratic involvement. And that itself is a subject of great academic discourse at the moment.
Thank you. Another question here?
Thank you very much for a very stimulating, outspoken talk. I'm Elizabeth Gibson Morgan. Apart from a policy of quotas, could we perhaps explore two other options, which would be perhaps the abolition of the split legal profession, all the more as it was officially abolished with the creation of solicitor advocates? And what do you think perhaps of introducing a form of French type of career judiciary? And I think it is the view of Lady Hale that I also admire very much. Thank you very much.
We all love Lady Hale, I should say. Not least because she's our only woman judge, and she's an out feminist. Our only woman Supreme Court judge and an out feminist, which is very brave, I think, in that environment. As to the abolition of the split legal profession, for those who don't know, aren't familiar with the system in the United Kingdom, we have a split profession. That is, we have an advocacy branch, those are the barristers, and we have a non-advocacy branch, and those are solicitors. There's a blurring of the distinction now for reasons I need to get into. But it's commonly said, well, if you allow the other part of the profession, those are solicitors, to enter the senior judiciary, you'll increase diversity. That's possibly true. For myself, I don't think it's the only answer, because at the senior levels in the solicitor's branch of the profession, in what are called the magic circle firms, those are the elite firms, there is also disproportionately higher numbers of men and higher numbers of men from privileged backgrounds. So yes, it may improve the position, but I don't think we should regard it as a panacea, and I think we ought to be careful of pushing that for fear that we just it backfires in the sense that we have many more solicitors, but in fact it doesn't introduce diversity because of the way the solicitors branch of the profession works. As to a career judiciary, we're very unlikely to have a purely career judiciary, a pure career judiciary in the United Kingdom for historic reasons. I mean, in France, you have a system where, as I understand it, people leave university and go into the judiciary. So they train to be a judge, they enter the junior branch of the judiciary, and they move upwards. That has caused, as I understand it, what's described as the feminisation of the junior level of the judiciary in France, which causes its own problems. It's led to a reduction in status, a reduction in financial remuneration, and so on. But in any event, it would result in a real shift away from the model of the judiciary that we have, and it's not going to happen. But what we could have is a greater career structure. So for the moment, presently, barristers move sideways from the senior end of the profession to the senior end of the judiciary. We could have greater movement from the more junior ends of the judiciary, which tend to be more diverse because they attract lower status. So we could have more movement between the levels, which I think would be something progressive, and again many have called for, and I think would be beneficial, yes. I don't think we increase diversity at senior level very quickly, which is why I think we need quotas to address the critical mass issue fairly quickly. But yes, as a longer term solution, I think that would be beneficial.
The last question.
Okay, thank you very much. I'm Emily Sweeney. I have a question. I don't know anything about the judiciary system in the UK, but I'm very much interested in education, and I was wondering if there was any type or even a possibility, considering the system, of a kind of a mentoring or pipeline system that would sort of promote the introduction of more women in the judiciary in the UK. Maybe you're mentoring someone right now.
I'm not a judge, I'm afraid. They wouldn't have me, I think you can be sure about that. I think there is a lot of, I think we should have a much more structured system for gaining access to the judiciary. One thing I think we should do is have much greater training, so we should have some opportunity to become trained in the skills that are required of judges. As a senior barrister, it's assumed that if you work your way up to the senior end of the bar and become a Queen's Counsel, somehow by some process of osmosis, you develop all the skills that are required of a judge, even though the whole of your professional career has been, as an advocate, putting forward a partisan argument. My view is we should have a more structured entry system, so there is training, one can go to a judicial college, learn the skills, be mentored, shadow, and so on. So yes, I think that's something. Mentoring, if it's formal, yes. I mean, we have informal mentoring, it's just that it's provided to male barristers. So yes, I agree we should have a more formal structure. Mentoring, no doubt, would be a valuable part of that.
So one last question.
One last question from our dean, from the Faculty of Administration and Communication. So I'll be the translator.
Thank you.
So our dean had the impression to discover through your speech the judiciary of the 19th century. And his question is, wait a moment. In France, we say that institution makes the one that
The institution creates the function.
Yes.
The institution makes the function the position.
So does that mean it's suggested that we dispense 19th century justice?
Is it the same? Is it the same? I mean, in France, this is what we say. Is it the same in the UK? In the institution? What? This is the question from us.
I'm not sure entirely. So this is my fault.
No, I think that it is the structure, the institution itself that creates, that generates that type of attitude and gender discrimination. Would you agree? Now, it is very difficult. Is it the people or is it the institutions?
It is the institutions which are populated by the people that reinforce the institutions. They are self-reinforcing, and that is one of the problems we have, that the more men that come into the judiciary, the more male the institution becomes, with all its habits, with its structures, with its inherent values and so on, and so it replicates itself and replicates itself, which is why we need women to knock down the doors in very large numbers, chuck out the men and start from scratch. But it's not going to happen very quickly. Sorry. Pardon.